Hi Muskan, hi Rohin. Uh, we're still waiting for Professor Jayna to join, and we'll just wait for a few minutes so that a few more participants join in.
Sure, thank you.
Okay.
Thank you. Thank you.
Um, okay, let me know if you can hear me now.
Yeah, Kanav, we can hear you. Yeah,
Okay, great. Thank you. I just wanted to check.
sure, sure. Um, Good evening, everyone. I hope I'm audible and visible perfectly. And thank you for joining in. I'm Prajwal Rathor, one of the co-conveners of the National Law School Queer Alliance, which is a queer collective on National Law School campus. We are conducting this event jointly with the Law School Policy Review, which is an online law and policy platform run by NLS students. We have Nidhi and Sarthak from LSPR here. Today, we will be unpacking the 19th October verdict of the Supreme Court of India in the marriage equality petition. To guide us along the way in this understanding of the verdict, we have with us an amazing panel. We have Ms. Jayna Kothari, who's not with us right now as she's running a little late. But Ms. Kothari is a senior advocate and the executive director of the Center for Law and Policy Research. Her research interests include constitutional law, gender and sexuality law, disability rights and discrimination law. Previously, she had argued the constitutional challenge to 377 and the adultery case. She has been actively involved in the marriage equality petition and has argued the same before the Supreme Court as well. And we have Ms. Kothari with us as well now. We have Rohin Bhatt, who is a queer rights activist, a lawyer practicing at the Supreme Court, and a bioethicist. Their work focuses on constitutional law and bioethics, with a particular focus on feminist and queer approaches to bioethics to make healthcare policies more available and more inclusive. We also have Muskan Tibrewala, who is the assistant director at the Center for Justice, Law and Society and Marginalization Clinic. Their work includes pro bono legal aid and research on gender and sexual equality in law and its intersection with marginalized identities. Finally, we have Kanav and Sahgal to guide us through the session and moderate it for us. Kanav is Samvidhan Fellowship Program Manager at Vidhi Centre for Legal Policy and Communications Manager at Nyaya. Kanav specializes in global gender politics and the law with a focus on gay rights and abortion rights. I hope that this panel is a great learning opportunity for all of us. Over to you, Kanav.
Thank you so much for that lovely introduction, and I welcome all the panelists. I want to first congratulate and thank the NLS Scottish Society and Queer Alliance for putting this together. This is a really important conversation to have, especially in light of not just the impact of the judgment and what impact it might have on other rights, but also given the fact that there's a lot of misrepresentation from the media. There were 4 separate opinions that came out, and so the media has also unfortunately incorrectly interpreted the judgment. So we will speak about that, and it would be great to hear about what the panelists have to say. So the flow of the presentation, the discussion is as follows. I'll start with some opening remarks, and then I'll pass it on to Jayna ma'am. If you could start with you, we would start with you, and we'd love to hear your initial thoughts on the judgment. After which we'll move on to you, Rohin, and we would love to hear your thoughts, and then we'll move on to you, Muskan. So 3 to 4 minutes per person. After that, I've prepared pointed questions for each of you, and I'd request each of you to spend 15 to 20 minutes answering those. In the meantime, the audience, and I can see we have quite a few attendees, will have questions, so they can put them in the chat box or put them through the Q&A option. And towards the end, we'll try to answer all the questions. If there are similar questions, it would be great if we could club them together. And it would be great if we could try to answer as many questions as possible, because this is an important judgment and there is a lot that we need to get into. So without further ado, I'd like to start by just sharing something that happened at Vidhi the day before the judgment. We have a WhatsApp group, and we have this WhatsApp group, and the day before the judgment, very lightheartedly, we asked each other, what do you think the outcome of the judgment would be? And most people voted that the decision would be a 4-1 decision in favor of the petitioners. Some said it would be a 3-2 verdict. One person had said no relief will be granted, and we laughed at that person. And the next day in the morning at 10:30 a.m., we gathered in the basement. I was not there in office, and we watched the proceedings, the live streaming of the judges reading out their opinions. And by the time it was 12:30, we were quite surprised, because it turned out that one person was right. And we asked them, how did you feel being the person who was right? And she said that, I felt strange, but this is not the outcome that I expected. And I think a lot of people within the LGBTQ plus community feel that way. Now, when I read the judgment, I was reminded of something, a book actually that I read a couple of years ago. For those of you who follow abortion rights and abortion law, you might be familiar with a lawyer or a case called Planned Parenthood versus Casey. It was a very important case in 1992 that upheld Roe v. Wade. And there's a book written by Catherine Colbert, who, and the name of the book is Controlling Women. It's a wonderful book where she goes behind the scenes and talks about the politics of the court and the politics of abortion rights in the US. And in chapter 3 of the book, she says something that really resonated with me, and I'm going to quote. She said, and I quote, "Arguing before the Supreme Court is informed by the lessons of Sesame Street." Remember that? It was a cartoon that some people used to watch when they were kids. "You need to learn to count, and the only number that matters is 5, the necessary votes for a majority." And she said this in the context of a conservative justice being appointed at the Supreme Court at that time. Now, when I read the judgment, and of course, the panelists will expand on the impact of the judgment, it was a clear 5-0 verdict against recognizing the constitutional right to marry, but also a 5-0 verdict recognizing the marriages of transgender persons within a heterosexual framework. When it came to the legal right to recognize civil unions and adoption for LGBTQ plus people within the adoption regime, there was a split. It was 3-2 against. So it was just one vote away from anything substantial. And that's when I remember this quote. But that being said, this is all in the past, and these are hypotheticals. There's no point leaning and imagining what hypotheticals will be. It's important to think about the future, but also remember that there's strength in numbers on the court and also outside in terms of mobilization, getting people together to talk about this issue the way NLS has done. And it's fabulous that you are organizing this conversation and bringing us together. So without further ado, I'd like to start by asking Jayna ma'am, if you could please share your initial thoughts on the verdict. You have been outspoken, you've been advocating for LGBTQ plus rights for a long time, you've been speaking, you've represented petitioners in the Supreme Court before, so this is not new territory for you. Many of us were surprised. I was very surprised by the verdict. What are your initial thoughts on the verdict?
Hi, everyone. Thanks. Good to see some familiar faces here. So, yeah, I think the verdict did come as quite a shock and quite a surprise. I think one of the main issues which I felt was actually rather surprising and was the fact that the court went on to hold that there is no fundamental right to marry under the Constitution. And, this is very, very important declaration. It takes back a lot of students that we thought had already developed. The court gave a very nuanced reasoning for this. The court held that its previous decisions in some of the judgments in the context of right to marry was not actually recognizing a fundamental right to marry, but the fundamental right to choose a partner of one's choice, and made that kind of narrow distinction. And went on to actually hold that there is no fundamental right to marry. I think that is that proposition, because it does impact not just issues of gender identity and sexual orientation. It affects everybody, right? It impacts the fundamental right to marry of all, and that is an important. It has a huge impact, and we'll have to see how we go forward from here. On other, while it rejected the relief that most of the petitioners sought that the Special Marriage Act be read in to include spouse or person, a gender neutral term. It went on to, I would say, small silver linings. Should to some extent take the conversations forward. On the issue of trans rights, it held that trans persons in heterosexual relationships do have the right to marry. Yes, a lot of people have said that, is this new? This was already granted by the Madras High Court. But I think it's important that the Supreme Court made a declaration, because ultimately the Arun Kumar judgment was just of the Madras High Court. And one of the issues, at least that we had argued for the trans petitioners, is that there already is a right to marry. Of course, we wanted it for all trans persons. We wanted it for all, not just people in heterosexual relationships. So to that extent, the court qualified it. But I think even to this limited extent, it makes a move forward. We hope that this declaration will enable and make it easier for trans persons in heterosexual relationships to get their marriages registered without the need for a TG card, without the need for medical reassignment documents. So let's hope that that happens. And the third, two other points is that the court held that they held differently on civil union. The minority held that there should be a civil union supported by legal institutionalization like of a law. The majority said no, they can't go to that extent, but recognized relationships between all persons and the right to protection under those relationships. Yes, it's a limited recognition, but I think that's important as well, because a lot of the cases we see are of people in queer relationships where they're really being harassed. A lot of our work is actually going to court to file quashing petitions against really frivolous FIRs which are used by family members. And we hope that this part of the judgment kind of hopefully puts an end to that. And the final bit, again, these are things that I have focused on in my reading of the judgment. The final thing is that the court that there is discrimination on the ground of sexual orientation, and that there is no law to address that. There is a Trans Persons Protection of Rights Act, which at least on paper has a recognition of discrimination against persons on the basis of gender identity, but there is nothing for sexual orientation as a ground, and therefore you need an anti-discrimination law. I think these are good observations and can be used by the movement. So yeah. Of course, overall, the judgment certainly didn't go as planned. Can we take some of these small silver linings forward?
Thank you so much, Jayna ma'am, for summarizing the judgment for us. And I also had the privilege of reading your article in the Deccan Herald, where you actually highlight the silver linings of the judgment, notably, of course, the expansion of the Madras High Court ruling, Arun Kumar ruling, which is now part of our law. And also recognizing the discrimination that the LGBTQ plus community feels, at least that has also been recognized. And yes, it did not go far enough. And we will discuss the impact of this verdict on other potential judgments as well. You spoke about frivolous FIRs being filed by family members, especially not just in the context of queer couples who wish to live together, but also interfaith couples, intercaste couples. And Rohin, moving on to you now, I've been following you on Twitter and social media. You have also been writing extensively about the judgment, and you recently tweeted about a very important issue before the Allahabad High Court, where the Allahabad High Court, bench in the Allahabad High Court held that an interfaith live-in couple who were between the ages of 20 to 22, I'm quoting the bench, they said that this is time pass, that live-in relationships like these are time pass because they're too young. And it made me wonder, this is probably the first time that a fundamental right is being thought of or being spoken of as being time pass. It really was surprising to me. And this is an issue because, and you also note, and you've also written about this in your op-eds, Rohin, that the right to marry is not being granted not just to queer people, but to anyone, which means in the absence of an SMA or an FMA, no intercaste marriages, no interreligious marriages, no transnational marriages. So this is a really shocking verdict. So over to you for your opening thoughts, Rohin. What do you have to say about the verdict and its impact on not just the LGBTQ community, but everyone else?
Right. I think, if I'm being very honest, I think, Ms. Kothari is quite optimistic. I'm not so much. I think this is a judgment that is written in bad faith and that is disingenuous. And I have reasons for saying it. Let's look at the first part. If you look at the majority opinion authored by Justice Bhatt, he first creates a difference between a freedom to marry and a right to marry. And then he uses both those terms interchangeably. Why create the difference in the first place if you don't want to, kind of develop jurisprudence based on that difference? Now, second thing, if you note, if you go back to Naftaj, because first thing I did was to go back to Naftaj. Naftaj relies on Shafin Jahan and Lata Singh to only talk about the choice of sexual partners. But if you go back to the original judgments, both of them say that there is a fundamental right to marry. The court, however, in its judgment, the majority or the minority does not say at any point that these judgments are now overruled. So this leaves these judgments in very dubious position on a legal footing. Now we've seen, in the past 6 to 8 months, various anti-miscegenation laws come into force across the country. Now they're done under the guise of forcible or illegal conversions for the purpose of marriage, and they're colloquially called the love jihad laws. Now those laws are also under challenge before the Supreme Court. A bunch of petitions have already challenged them. Now this judgment, to that extent, kind of preempts those petitions. Now, if I were a part of the legal team there, my first argument was, look, there's a fundamental right to marry. Now, if this fundamental right to marry argument is dismissed at the threshold because this judgment holds that, a superior holds that, then what are we left with? We know for a fact that it's extremely difficult to get relief more so when the couple is intercaste or interfaith. And there's an added layer of marginality when it's also queerness kind of added to the mix. So it's quite dangerous to start off with. So much of this judgment traces the Hindu law's development around marriages, right? Both in Justice Narasimha's as well as Justice Bhatt's opinion. But they forget that Hindu law was never supposed to be argued, right? At the very first day, we were told that, no, limit yourself to SMA. How does the bench then go on to rule on the Hindu Marriage Act, even in respect of transgender persons? The second thing, Justice Bhatt notes at the very beginning of his judgment that the challenge to the notice regime was given up. In paragraph 3 of his judgment, he says that during the course of the hearings, this court indicated that this was not a question of law that necessitated a 5-judge bench ruling. The first time this fell from the court was on the 7th day of arguments, around 11:30, when the solicitor was halfway through his arguments. At 2 o'clock, we rushed multiple seniors to the court. Mr. Ramachandran was there, Mr. Grover was there, Dr. Singhvi was there, and we mentioned that you cannot do this. If you do this, because of heightened vulnerabilities, you will be, I still remember Mr. Raju Ramachandran saying that the relief granted will be illusory. And yet the court, for some reason, notes that the issue is left to be consideration by the smaller bench, when in effect it was extensively argued not just at that mentioning, but also in rejoinder. Never was it pointed out to us that we are not touching this issue. And my final comment is with regard to Justice Narasimha's opinion, which I think is far, far more dangerous because it harps on and on about the roles customs play. Now, if we are to assume that, we must go back to the original judgment of the Bombay High Court written by Justice Gajendra Gadkar in Narsu Appamali. Now, nowhere once does this judgment in its entirety of 366 pages refer to Narsu once. So what happens to Narsu? Remember, in Sabri Malai, Chief Justice Chandrachud said that Narsu is prima facie wrong, but we leave it open for a subsequent bench to talk about it and decide on its correctness. Why is the bench relying on customs so much when there is no point of customary law being involved? Understand this. And one last point that I'd like to make is the distinction that Justice Bhatt makes between state recognition, solemnization, and registration. He creates a minute difference between those three. In the beginning, he says the petitioners here are seeking recognition. But by the time he comes to the third paragraph, it suddenly becomes entitlement to solemnization and registration. These are three very distinct processes. State recognition and registration happens through the state and is confirmed by the statute. A solemnization process necessarily requires, as I understand it, a religious backing. What is so solemn about marriage law in India is that it has the backing of religion. And our personal laws are thus a mix of not just the English common law, but also our religious laws. In interchangeably using these two in context of a secular law like the Special Marriage Act, I think the bench has kind of messed up multiple issues and kind of muddied the waters for future jurisprudence, not just on queer rights. Justice Narasimha, for example, says that Navtej and Nalsa are not binding. While that may be true for Nalsa, because it's a two-judge bench decision, Navtej being a coordinate bench decision of 5 judges is still binding on these 5 judges. Yet, without giving adequate reasoning for why Navtej is not binding, I think the bench forgets that, we are still bound by principles of stare decisis. And so I think we're going to be in a very dangerous position. And I think while this case was going on, I don't know if a lot of you were following that case, there was this interfaith couple in Rajasthan, which got caught in the crosshairs of a love jihad bogey, a queer lesbian couple. And it created a massive situation in Rajasthan. The local BJP MLA went there and created drama at the police station, and the teacher finally got bail. So, we're going to, as lawyers who regularly represent queer community, we have to kind of make sure that we are ready now to fight this out in courts, because I have no delusions about the fact that we are going to see more and more FIRs lodged. I have witnessed a spate of homophobia. I've had somebody call me up and say that police ended up at their house saying the Supreme Court has said you cannot live together, right? And whether we like it or not, our marriage seems to be the only form of social recognition that this society understands. And by denying us that, I think the promise of equal citizenship that we as queer people were granted in Navtej, I think the court has gone back on it.
Thank you for those points, Rohin. And I think even though this verdict does appear to be a setback, it is a setback definitely for the queer community. I was also very surprised with some parts of the judgment, especially the notice and objections, the part about notice and objections that it will be now considered by a smaller bench. I don't remember that being discussed during the live proceedings, because I watched the entire thing. And I think the point that you mentioned about the heightened vulnerabilities of not just queer persons, but also queer persons who are in an interfaith relationship, for example, makes things even more complicated. So I feel that the majority was not really able to look at it through an intersectional lens, and this is an issue that people in the social sector have been speaking about, not just in the context of queer rights. I also work in the context of abortion rights. It's again the same discussion that you need to look at abortion rights and access to MTPs through an intersectional lens. Unfortunately, it didn't really see that, and of course, the point about customs and traditions is very strange, given that a concession was made that we will limit the discussion to the Special Marriage Act only, and even despite that being the concession, it was found that there was no right to marry. So it really seems as if the petitioners were losing right from day one and have come out with practically nothing. Now I'll move on to you, Muskan. You worked with Karuna ma'am, and you've also been involved with this case and also the Bhopal gas tragedy remuneration case. So you were also there, and you've been involved with this issue, and I've also had the privilege of reading some of your work on transgender rights and some of your other published work. Since you were there and you worked on this case, what are your thoughts on the judgment? Do you share the view of your co-panelists, optimism, pessimism, maybe somewhere in between? What are your thoughts?
Hi. Thank you. Thank you for your wonderful comments, Rohin and Jayna ma'am. So I think I would be somewhere in between. I do see, for example, Justice Chandrachud in his judgment talks about Section 3 of the Trans Act and how there is actually no remedy for anti-discrimination in the act itself. And therefore, the remedy there would be to go to the high courts, which is fairly useful because it is against both state and non-state actors. And this is something that the majority also concurs with in terms of their ruling on the Trans Act. In terms of the reiteration of NALSA and of Tej, normatively, it is useful. But the normative force of the Consti bench, like Rohin said, saying that there is no right to marriage. When it goes down, and we've seen this with 377 also, that when it flows down to the police stations, to families, it translates into the fact that what you're doing is illegal, what you're doing is wrong. And so that is going to be that is going to make things tougher on the ground, and as lawyers we have to be ready for that. In terms of the judgment itself, the court on the first day said that they are going to be looking at the Special Marriage Act only, not any of the other laws. And towards the end, when we come to the judgment, we see that the SMA is being avoided, more or less. With Justice Chandrachud's judgment, he said that because there is no essential remedy that we can give here, then we don't really see the point of going into its constitutionality, which is a weird sort of constitutional path to take. With Justice Kaul, it was surprising that in 3 paragraphs, he cleanly said it is violative of Article 14. It was beautiful. Like, this judgment could be just 3 paragraphs. With Justice Bhatt, of course, there was a lot of back and forth on objects, on effects. So the fact that the list was the SMA, and then this judgment became about so many other things but that, is something that was quite staggering. Second, I think the court has, throughout its judgment, just sort of underestimated the power of its own jurisprudence and its own court. They keep, for example, Justice Bhatt in his majority says that the court has never created social structures, and this is not something that we can do by a judicial diktat. And Justice Chandrachud responds to that saying that we're not saying that you should create a social structure by judicial diktat. We're just saying that the state has an obligation to. But I mean, NALSA was essentially recognizing, like legally recognizing social identities, not just transgender identities, but also a third gender, right? Someone that doesn't necessarily fall into existing labels and identities that we have. So to say that the court has not in the past, I mean, even with trans rights, for example, the court has recognized Guru-Chela relationships before in the context of succession laws. So when you have recognized social structures of gender and sexual minorities, and you have done this even in the realm of family law, which is succession law, then why say this? And the second thing is, when we talk about customs, and although I agree with Rohin that that this shouldn't be about customs, this is very much about the law. Whose customs are we talking about? Why are the customs of the Hijra community? Why are the customs of the queer community not customs? Marriage is a social legal institution. There are social aspects of this. Queer people's customs require as much constitutional recognition as the majority customs that are followed in India. So the court, being this protector of the minority, even recognizing that, I mean, both Justice Chandrachud, Justice Bhatt go into a very long detail of the history of marriage in India, the fact that marriage is a precursor to the state, the fact that the state regulates marriage, and all of these other things. So regulate it. Like, we're asking you to recognize that this is an institution that requires rights and entitlements under the law, which you have done before. So I feel like throughout this this judgment, there's just a lot of underestimation of what the court has done in the past and can do here. It could have done so much more. It was a big disappointment, but I hope we can take the silver linings forward, prevent as much backlash that we can from this judgment, and see better days.
Thanks, Muskan. I think you raised some really important point, and especially the point about recognizing queer people's customs. It's something that didn't strike me as obvious But Justice Chandrachud does talk about Ruth Vanita's work, where she has highlighted the history of same-sex relationships in the past. So it is a valid question to ask, is that if you're talking about customs and traditions, what about the customs and traditions of the LGBTQ plus community? Also, to a point that you made, Rohin, about you receiving a phone call where somebody had said that, these marriages are forbidden. I noticed a newspaper article from Al Jazeera where they had written that same-sex marriages are now forbidden. So I actually had to issue a clarification. I decided to just post it on my LinkedIn because I noticed that the media was not reporting correctly, and this becomes a problem. Many people don't know that that Justice Kaul had ruled the SMA as unconstitutional. Now, unfortunately, that is not. He was the only justice who made that observation. But it's very interesting to know that that is there in as part of the opinion. So important for the media also perhaps to take note of. And to your point about new institutions, I agree that if the court has recognized the third gender category as a distinct entity, as a distinct legal entity deserving of equal rights, and recognize Guru-Chela relationships, it's very strange for the court to, in a way, diminish its own powers. Now, there is some talk that this is politically motivated, because there's a Article 370 judgment coming out. We don't know what exactly the reason is why the court kind of has left it to the state, or to the legislature rather, but we will see. It's really difficult to hypothesize, but this is also something that I've been hearing. So now we'll move on to the pointed questions for each panelist. And at this point, I'm sure I can see we have 47 attendees. So please start putting in your questions in the Q&A box. And it would be great if you can mention who you would want to have those questions answered by in the interest of time. So Jayna ma'am, I'll move on to you with a very specific question. So as a senior advocate of the Supreme Court and co-founder of CLPR, you've been working in this space for a while. And you have the advantage of experience and foresight. So you have highlighted the silver linings of the judgment. You've discussed that with us. You've also summarized the judgment for us. What comes to my mind is, what is the impact of this judgment on other cases that are pending before the Supreme Court? There are two cases that CLPR has worked with. So for those of you who don't know, just a bit of context. One deals with the constitutionality of the blood donation guidelines, in which the organization is representing Santa Khurai, who's a transgender activist from Manipur. And as per the current blood donation guidelines, MSM, transgender persons and female sex workers are not allowed to donate blood. The other one deals with a writ petition that CLPR has filed before the Supreme Court on behalf of their transgender activists, many of us would be familiar with, such as Grace Bhanu and Vijayavanti Mowgli and a few others. So these two cases are pending before the Supreme Court. I am sure that there will be more cases that might come up before High Court, Supreme Court. I gave the example of the Allahabad High Court case of an interfaith couple. What in your mind, Jayna ma'am, is the impact of this verdict, Supreme verdict, on the future of these cases and potential other cases that impact LGBTQ rights, transgender rights, queer rights, and the rights of quote-unquote atypical families and atypical persons in quote-unquote atypical relationships?
Yeah. So I think, on the blood donor PIL, on the blood donor petition, I don't think this may have any significant impact one way or the other. But I think there are a lot of petitions filed by many people, many petitioners challenging the Trans Act 2019. I think those petitions don't have a future, because I don't think those petitions are going anywhere, because more or less what the court indirectly has actually upheld. I mean, those sections were not discussed, obviously, in the marriage case, but it has kind of indirectly upheld that this anti-discrimination provisions in the Trans Persons Act is there. They are there, and therefore we need something for sexual orientation related discrimination. So I doubt that challenges to the Trans Act would go anywhere. That's my personal view. Remains to be seen how it flows, but that's what I think. And other petitions, I mean, of course, I don't know which are the other. I mean, there are. I don't think there are other petitions that may have perhaps an impact, but I think the larger impact this may have would be on petitions where these religious freedom to marry laws are challenged, and that will have and this judgment will have will actually impact it negatively, because it says there is no fundamental right to marry. So then those challenges will be tough to uphold. And then we'll have to be creative, and we'll have to see how we could uphold that on privacy and other constitutional fundamental rights. So we'll have to be far more creative in those cases, because this obviously impact on some of those cases.
Thank you so much, ma'am.
Yeah, if there are any other questions, but yeah, if there are any more questions that come to me. But I do want to say, before we reach other questions, I think Rohin and Muskan both raised the issue of, the reference to the notice issue to a two-judge bench. The bench actually clearly had said it. Though there was a lot of opposition, I don't think that was a surprise in the judgment. The bench had clearly said it that afternoon that this question we are not addressing. We were all there. Yeah, Rohin, you want to add?
Yes, I think they did say it then, but then I think if the moment they let us argue that in rejoinder at length, Dr. Singhvi spent half an hour, Mr. Grover spent 5-10 minutes.
But they had more or less kind of, I think they were hearing it briefly, but I think on that afternoon when that issue came up, they clearly said, oh, this question we're not going to address, let it go to a two-judge bench. So kind of that was done and dusted at that point, but yeah, I'll end.
I think then the question arises, when will that two-judge bench be constituted? When will they hear this case, and when will that be decided? Because this is also important. But anyway, we will come to that. It's surprising, ma'am, that you mentioned that if I've understood you correctly, you're saying that the Transgender Protection Act, the challenges to the constitutionality of the Transgender Protection Act, you're saying that they most likely will not have a future, if I've understood you correctly. Okay.
Yeah, I think so. Doesn't look like there's much hope.
Okay. On that note, I'll move on to you, Rohin. I have a question on unenumerated rights for you, because to a large part, Justices Bhatt and Kohli, they speak about this. Specifically, I'm talking about paragraph 55, where a reference is made to a poet, and I want to go on to those references. And for those of you who don't know, I will read parts of those out. So in paragraph 55 of their opinion, Justices Bhatt and Kohli, they talk about the positive obligations embedded in the framework of fundamental rights. So what they essentially say there is that not the fundamental rights are not enjoyed by everyone to an absolute extent. There are certain restrictions, we know that. But they also say that when it comes to unenumerated rights, the court ought to address them only if there is some sort of state action that restricts that right, either implicitly or explicitly. And then they give this illustration, just quoting a bit, where they say, quote unquote, quote, consider a poet who wishes to share their work with the public at large. Now, provided that there's no direct restriction having a chilling effect, the state's role in enabling or facilitating that freedom enjoyed by the poet is limited. The court cannot direct that the state must create a platform for this purpose. This would be a stretch. So what they're essentially saying is that if the state does not directly or indirectly not offer the poet a stage to perform, then there's very little the courts can do. And there was another analogy made with, the citizens demanding the court to request the construction of the road in the absence of road transportation policies. So Justice Chandrachud addressed that. I want to ask you, Rohin, what are your thoughts on this analogy of comparing the petitioner's demand for the right to marry, comparing that with a poet wanting to stand on a stage and sing a song? To me, I found the comparison very, very strange. Nothing more than that. Can't really say more than that. And also about unenumerated rights, because the court has adopted a transformative constitutional approach. In Navtej, they spoke about the progressive realization of rights. And here, all of a sudden, I don't see that. And you've also highlighted this in some of your tweets and in some of your op-eds. You didn't really see the transformative constitutional doctrine here. So your thoughts on this comparison with the poet and the road construction, and on transformative constitutional perhaps gone wrong in this judgment?
Right. I don't even want to, I think, address the road construction argument, because I think it's a strawman argument. So let's not waste our time on that. Let's talk about the poet. Now, I want to go back to the first thing that I talked about, is Justice Bhatt's distinction between a freedom and a right. The way he frames Article 19 versus Article 21, where Article 21 also includes a claim against the state, because it's a right and not just a mere freedom. And here in 55, and that's exactly what my note says, is that he kind of obfuscates those distinction between a right and a freedom, right? A poet has a freedom to speak. A poet does not have necessarily a right to speak. The poet cannot demand that let the state make a road, right? But we as petitioners had argued that there's a violation of 21 in terms of right to health, because mental health of queer people who are deprived of marriage is robbed. Mental right of choosing a partner, right? Of living to what we called in our written submissions a truly meaningful life. All those rights were violated. And then, of course, there were other arguments around intimate association and all of those. But this distinction between a right and a freedom that Justice Bhatt himself creates in the initial parts of his judgment, which he then obfuscates in the latter part, I think is quite strange. The state's role, but look, we are not dealing with a case where a poet is not allowed to speak or a poet is not allowed to publish. We are living in times where the state says that no, only people who write in prose will be allowed to speak. Let the poets not speak. And in his own opinion, he notes that the petitioners who have not argued that an absence of a regulatory framework is not violative of Article 15. Although Mr. Vishwanathan, as he then was, had argued it at length. So, it's strange, because it's a straw man, because that is not what the argument is. The argument is that the state says that only writers who write in prose should be allowed to write and will only be allowed to write by the state. Justice Bhatt's opinion says, no, this is discriminatory, but the poet cannot force the state to write. I think that's how I think a more accurate framing of this issue, as I see it, would be.
Thanks, Rohin. I think it's really important that you've spoke about the right to health. I'd written an article for the Deccan Herald where I looked at some journal articles that were published in the US, where they've actually analyzed the impact of marriage equality in the US with the mental health of queer people. And they found that legalizing, that if the state grants that legal recognition to same-sex couples and other queer individuals, it not just improves their mental health, it improves their children's mental health, because their rights because the law now recognizes them and their parents. And it also positively impacts the mental health of society. Young people who grow up queer know that there is a future for me. I can choose to marry a person I love, settle down with them, and I will be treated the same way as my brother or my sister who happens to be straight is treated. So there's a lot of rich evidence on the positive mental health benefits. And strangely enough, in the judgments, in both the majority and minority judgments, I found that they really highlighted the issues faced by the petitioners. They wrote it down, but nothing. But it just seemed to me like a wastage of paper, because where's the action? Why have you not taken the adequate steps to address these issues? You could have done it. That's one point. And I think the other point I'd like to make is that you've explained it really well, that the state seems to say only people who write in prose will be allowed to speak. So the Pink List, for people who don't know, it's India's first repository of it's a database which basically contains information about which Lok Sabha MPs have spoken in favor, against, or remain silent on queer issues. And this question of same-sex marriage was raised in Parliament a couple of times. There was a private member bill that opposition MP had tabled, and I think she was from the NCP. Never made it, never got passed. Dr. Shashi Tharoor in 2015 tried to table a bill on 377, nothing happened. So legislative inaction has happened. So the state has actually not acted. It has intentionally perhaps not acted. So to say that, the state has not done anything yet, we are waiting for some sort of negative state action is actually factually incorrect. It's documented by the pink list. So, with that being said, I mean, we've
shown to the court. And shown to the court.
And shown to the court. Yes, I think it was Advocate Anand Grover who showed it to the court. And interestingly, the pink list is not mentioned anywhere. So I just also want to highlight that it's not missing it's missing in all of the judgments. So Muskan, and by the way, we've started receiving questions. So Muskan, I'm over to you now. So let's talk about perhaps the next actionable step, which is that all the 5 judges, in their opinions, have recognized and have written this in their opinions, that the Solicitor General had stated that a committee chaired by somebody no less than the Cabinet Secretary will be constituted to set out the rights available to queer persons in unions, and also defining the scope and benefits accruing to them. So that is mentioned in the judgment. But there are a lot of issues with even this mention. One being the fact that general elections are scheduled for next year. We know that this is not an issue that most politicians like to touch. In fact, a couple of them came out against marriage equality during the hearings, and many of them refused to speak about it directly. There are also no specific timelines set regarding when this committee will be formed. And there's also a legitimate question that I have as to who will be a part of this committee. Will it represent the intersectional voices of the queer community or not? I think this was also an issue raised with the Transgender Council. And, it has been formed, and it is just what it is. So, Muskan, what are your thoughts on this committee? It seems to be the next step. But given the fact that this does not seem to be a politically winning issue, no party seems to be willing to really take this on and add it to their election manifesto. We would hope that some of them would. There's a lot of uncertainty about next steps. And this is not just an issue that I think affects lawyers. I think, yes, there is a certain amount that lawyers can do. But I think it seems to me that the buck has now been passed to the people, who will now have to try to mobilize and try to convince their elected representatives to make this a part of their manifesto. So in your thoughts, what do you think are the next steps with respect to the committee, and also maybe out of court kind of mobilization?
I mean, in terms of the politics of the movement, in terms of campaigning with society, with public figures, with politicians, it's always an important and integral part of any movement, right? It's never just restricted to the courts. And it has to be a simultaneous process that happens. Even more importantly now, given that there is this committee and this committee might do something. But I mean, in the entire judgment is sort of replete with, all of the judgments are replete with how it's just not possible to give a remedy here. We recognize that you're discriminated against. We recognize that there are issues, but there is no remedy. And so they say that this committee is what we can give you. But in its own jurisprudence, the Supreme Court has formed committees in the past, but these committees have had constituents by their own orders. These committees have had time frames. There have been continuous mandamuses where these committees have to report back. If the Supreme Court feels that because this law, because any sort of legal recognition that they accord might affect other laws, the committee could have been asked to make a report on this, on what other laws need to be changed. If this needs to be a continuing conversation, it could have been had. But at this point, the way that this sort of committee has been formed, the fact that its mandate is basically queer people go through issues, please see what you can do about it, state, is it's something politics could have achieved and would not probably need a 5-judge bench of the Supreme Court. If there is a 5-judge bench, then that Supreme Court could have had more accountability for such a committee, could have given the scope of it, could have given it a more sort of clarity on the rights of the community. So, I mean, of course, in terms of next step, this is a committee. I mean, in terms of the talk that has been going on with the movement, I've seen a lot of groups talk about, oh, should we start drafting representations to this committee? Because any win, any small win is a win. We need to engage with it. We need to see what we can get out of it. But given, like you said, the lack of information on its constituents, given lack of a time frame, given lack of a clear mandate, how this committee's actions are going to help us get where we want to is a definite question. But given that it is open-ended, it is possible for us to, again, campaign with political figures, to campaign with the government, and perhaps make this committee into something that's better than what it is right now. But I mean, the work is set out for us. But politics has and always will be an inevitable part of any social movement. It cannot just be the court that has a say.
You know, I agree with that. The fact that politics has to be involved. My concern is that, you know, I've been following the politics of gay marriage in the US. It became so divisive, and it reached a point where I was looking at the Equality Act. So the US Congress has been trying to pass the Equality Act, which is a law that would remedy, that would replace certain provisions of the Civil Rights Act and basically expand the scope to include the queer community. It has been so partisan, where the Democrats are on one side, Republicans are on one side, and where in one particular year, you had 7 to 8 Republicans vote with the Democrats. It passed the House, but it just kind of languished thereon. So, and of course, throughout the 2000s, there was a spate of same-sex marriage. There was states which granted recognition to marriage, same-sex marriage, and some states that banned it explicitly in their state constitution. So it became like this patchwork of laws, something similar to what we're seeing with abortion laws now as well. And I've personally been very, very concerned about having use of politicians using the LGBTQ plus community as pawns, and, you know, making promises and then not fulfilling them. And it seems to me that that is what's going to happen. And as you rightly pointed out, that even politics could have achieved this committee. But now that the Supreme Court was involved, they've not only taken us, they've not only kind of put us back to where we were 5 years ago. There doesn't really seem to be any change. But they've also mentioned that there is no constitutional right to marry. And that seems to be more of a setback than a path forward. Had there been, perhaps, and going back to my point about Kathleen Colbert, had there been, you know, a right to at least form a union or adopt, I would say at least a union or adoption is probably one small step ahead. This seems to be a step back, but we will leave it, and we are where we are, and we have a lot of questions that have also come up in the chat box. And I can see that it's almost 6:30. So I'll take up some of the questions. And most of them have addressed them to you all. Some of them are not. So I'll take some of them. Jayna ma'am, I'll start with you. So there's a question from Kishna Shetty. They're asking, have similar judicial setbacks to the queer movement been overcome, where silver linings of these seemingly regressive decisions have had an effect in future cases? Because it seems that the jurisprudence so far has been positive. This seems to be like a setback, but what are your thoughts?
I'll address both those questions, this one and also by Mihir on the Trans Act, because those are addressed to me. I mean, yeah, there have been setbacks. The NAS Foundation was the biggest setback, and we came back, didn't we? I mean, it was it did happen. Navtej happened after NAS, and so we'll have to see how we go forward from here, and we'll have to plan how we go forward. We have to. I mean, it is a setback, but we have to look at how to move forward. We have to strategize on how to move forward. So let's look at that. It has happened in the past. And despite the Supreme Court giving negative judgments, there have been ways in which the same judgments have, we've had Napage and the privacy judgment and NALSA happening. So let's try and look for how to, take some of the small wins and push those. And the question that Mihir asked, that about the Trans Act and what does this judgment, what is perhaps the the observations made. I mean, I think most of the judgment, the Chief Justice says that there are pending challenges and those pending challenges are to be decided separately. But despite stating that, I think the general reference to the Trans Act is largely to say that the Trans Act addresses questions of discrimination. Now, the court may say that while it is addressing it, it does not mean that the discrimination has gone. It does say that there are some inadequate remedies, all that is there. But the general tone is a tone that, yes, there is a law that is there, that is drafted pursuant to NALSA to address issues and the rights of trans persons. So I think when that general that's the general tone of the judgment, that will make it difficult to challenge the nitty-gritties of the sections. And, I think medical intervention is one aspect, but the other challenges that are other issues of challenge raised are the other sections, the punishment, the unequal, the penalty given to offenses against trans persons, issues of family. So many, of course, none of those are addressed. But I think we've had not just this judgment, we've had one or two other judgments where the Trans Act is generally kind of referred to. And, the referral will give it a tone that, yes, the court has actually in agreement with it. So I think the petitions challenging the Trans Act need some thinking, how we move forward. But yeah, I think those are the questions addressed to me.
Thank you, ma'am. Since we're talking about challenging, we spoke about the petition challenging the Trans Act. Some people have also put this as a question, and I'll ask you, Rohin, to address these. People have started asking, one person asked, is this judgment final? Somebody else has asked, what is the tenability of review petitions? I think the first thing that came to many people's mind was, is there a way for us to overturn this verdict? Is there a way for a larger bench to be constituted to maybe reconsider this verdict as was done with Navtej? What are your thoughts on that? Do you think that's the right approach, or do you think that this is settled the way it is and the next step should be to kind of take it to Parliament?
No, I think, look, I speak for myself that we are in conversations with our clients about whether they want to file a review or not. So a review is definitely not something that we've written off. We are yet to take a final call on whether to file a review or what to do. But there's no way we can, throw ourselves at the mercy of this committee. Like Muskan was saying, what are the terms of the reference? What are the time frames? How did this committee come about in the first place, right? There's no pleading to that effect. There's no affidavit to that effect. This committee was nothing but a dilatory tactic used by the solicitor to kick the can down the road, and somehow the courts seem to have latched on to this. I remember when the committee was first proposed, Bar and Bench did a story saying the Chief Justice has asked the petitioners to go to the committee. And that story somehow got a lot of traction. And I think that kind of, as I see it, that kind of, latched on to the judges' minds that this is a very interesting way. This is only the second time when in constitutional adjudication, when the courts are told upon to decide on a right, they asked the petitioners to go back to a committee. The first one was when the farm laws were presented and Justice Bobde constituted a committee, right? When a constitutional court is called upon to adjudicate on rights, it cannot pass the buck. There's a reason Article 124 says that, look, you are tasked with the final interpretation of the Constitution. It's not for a committee, no matter how powerful the committee, how high power the committee may be, a committee cannot adjudicate on rights. So that is the first part, I think. And whether to take the ball back to Parliament, I think doing so before 2024 elections would be a fool's errand. Subject to the outcome of what happens in 2024, I guess. So at least until next May, we should all, kind of give up on this if we want the Parliament to take it, which I don't think is a fair ask of petitioners. So we'll see. I think, even if our petitioners don't agree, I don't think this judgment will be allowed to stand. I think there'll be reviews filed, and if the reviews are dismissed, there'll be curatives filed. And even if the curatives are dismissed, then we live on to fight another day in a fresh case where we ask a court to reconsider this. So I think the answer is there's no answer right now. I think, but I think one of the ways that this litigation has taught us is, I think, we're not talking within ourselves within the movement, right? For a lot of us, we knew about the petitions when they were filed in the Supreme Court. I didn't know about them, and I think I'm fairly active in the movement to know what's happening. Till one fine day, there came a post in the morning on Live Law that petitions have been filed in the Supreme Court. We thought, Delhi High Court would have heard it. There's a need for a greater conversation between those of us who are in the movement. And I don't think I want to blame person X or person Y. But if there is going to be litigation that concerns the entire community, then we must, at some level, of course, not divulge our legal strategies, but nevertheless, still hold a conversation about where we are going or what we are doing, right? And I think this is a time for reflection for all of us to kind of go back and think about where are we going wrong as a movement. With this case, I think, also think that the differences between the cis queer movement and the trans movement, I think those two movements are also kind of stopping, conversations with each other. And I think there's a need for, broadly speaking, a greater conversation to be happening within the movement, that, these movements don't necessarily become about persons so much so as they should be about the causes.
Thanks for that, Rohin. And I think I want to club in another question related to this, which was asked by somebody about the role of state legislatures. Now, I understand that this issue is complicated. What are the next steps? Why was the entire community not consulted? Initially, I remember some people were also a bit upset that horizontal reservations for trans persons seems to have not gotten the same amount of traction as marriage equality. The transgender, the constitutional challenge to the Trans Act also, I don't know, it just seemed to be within the media space, it just seemed to be somewhere in the back burner. It didn't really seem to get that much attention. This case seemed to have gotten a lot of attention and was just pushed through, and it reached, and we've already come to this point where we've already reached a judgment. So definitely some more conversations need to be had within the queer community, especially on horizontal reservations, which is very important. Someone has asked a question about state legislatures. Yes, elections are due, but what about, let's say, state legislatures, let's say maybe West Bengal, or let's say Tamil Nadu or Kerala, where perhaps there is a scope of convincing state governments. What are your thoughts on them enacting marriage equality laws at the state level?
I think that is definitely something we can consider, and consider lobbying with governments that, are open to having a conversation. But before going into 2024 elections, I doubt any government, even at the state level, will be willing to pick up for such a hot potato issue. I think, not saying that it's not worth a shot, but I have my reservations about whether or not this will happen.
All right. Muskan, I want to ask you a question regarding gender neutrality. Now, I'm addressing this to you because Karuna ma'am had addressed this issue. And I was quite, intrigued with this because it seemed to me that some of the petitioners wanted a gender neutral reading of the SMA, and that's what the court has focused on in their opinion, both the majority and minority. But then Justice Bhatt and Justice Kohli speak about how the gender neutral interpretation of SMA would, quote unquote, complicate an already exhausting path to justice for women and leave room for the perpetrator to victimize them. In other words, there are existing power imbalances between heterosexual unions, and our laws are not gender neutral. So Karuna ma'am had addressed this, and I've actually written a piece on the Vidhi blog that talks about her approach, which was slightly more nuanced, but I feel it kind of got left out in the conversation. What are your thoughts on gender neutrality in general and the way forward? Because this could be a potential wedge issue between some feminists who would want to keep laws, laws specific, gender specific to protect heterosexual women, and some activists, maybe gay rights activists, who would want gender neutral laws to recognize, you know, issues that the LGBTQ community face. What are your thoughts on this?
I think first off, I think it's really important to address in terms of all of the judgments and the way that they talk about marriage. You see that they talk about this as this amazing institution, but it is also a heteronormative institution. It's a patriarchal institution. It's been a site of oppression. And while we are asking for a right to marriage for certain reasons, it is important for us to engage with the institution of marriage as it is, and the many people who are going to come under it through this judgment. So for instance, Justice Chandrachud in his judgment says that the state regulates marriage in a way that it gives autonomy to both parties, which is just not true. And Justice Bhatt in his judgment, in fact, talks about how there is a sort of imbalance here. When you do create gender neutral provisions, you take away gendered protections that have been given to certain parties. The problem here is the way that we were approaching the remedy that we were seeking from the court. First off, in terms of the fact that the court cannot read down, read up, or tinker with it, like a lot of the judges were saying. In fact, if you see Justice Chandrachud's judgment and his directions with respect to Kara, he does exactly what we asked in the SMA for Kara. He says the schedules, mother, father needs to be read as applicant number 1, applicant number 2. So there was some sort of reading down done, more than just the provisions or more than just one provision in the very same judgment where we were told we can't change these aspects of the SMA the way that you want them to. But there has to be a recognition that if we want these rights and entitlements, which is what this whole thing is about, to go to everyone in the queer community, then the same sort of vulnerabilities that you associate with women are also associated with queer people. And not always the same ones, but say different ones. So for example, under the SMA, a woman has, and this is a right only the woman has, to file a claim for divorce from her original home, basically her Maike, like where she was brought up, because normally you have to file it from the place in which there was the marital home, right? And this is because in our society, women end up depending on men and go back home when there are some sort of issue. So this was a special protection given to women. If you look at trans people, for example, their protection would not need to be the natal family, because the natal family is also a site of violence for them. So what sort of protections would you then put in for trans people, right? What sort of jurisdiction requirements are there for divorce for them? So simply making provisions gender neutral is also not going to give queer people the rights and entitlements that we want right now. This is definitely a larger project, of which this is just the first step. So I think this issue of gendered laws, what needs to be gender neutral, and how our laws can accommodate queer people, and also because in queer customs, in queer practices, we don't necessarily only recognize sort of the heterosexual idea of a marriage, right? Unions are larger than that. There are different kinds of families that we envision. So how all of this is going to be encompassed into family law is something that is definitely going to need further examination. So it is an issue, and Karna ma'am had also spoken about it in court about needing to preserve the gendered protections that are given to women under the law. And also, in addition, we need to give further protections for queer people, because there also are certain vulnerabilities associated there. So yeah.
Thank you for that, Muskan. Karuna ma'am, there are a couple more questions. We are going to go on till 7, and then that will be our hard stop. So one question, Karuna ma'am, is about litigation strategy. This has been asked by an anonymous attendee, where they have suggested, where they've asked that hypothetically, if the petitioners had approached the High Court, and if the High Court had given an adverse, I'm sorry. Yes, Jayna ma'am. So this is a question that is being asked by an anonymous attendee. So if the petitioners had gone to the High Courts, and if the High Court had given an adverse judgment, it would have been possible to perhaps appeal and go to the Supreme Court. But now that a 5-judge bench has already kind of decided on this issue, a review petition and then potentially a curative petition seems to be, it is an option, but it is a very, very difficult option. So this is one question in terms of litigation strategy. Do you think that the petitioners made a mistake by going directly to the Supreme Court? The other question is about judicial activism, because a lot of countries, including the United States, United Kingdom, I believe, and various other countries, Taiwan also, they have, and Nepal very recently, the courts have actually granted the right, they've recognized the right to marry, and our courts have done the same. They've done the same with abortion, they've done the same with privacy rights, they've done the same with the trans gender category. So to say that it's judicial activism, like how does one deal with that criticism? Because the courts have justified those those verdicts in the past. They've found those rights in the Constitution, and yet when people criticize LGBTQ activists for advocating for the right to marry, they say that you're trying to be a judicial activist. You're trying to read things in the Constitution that does not exist. So there seems to be a kind of contradiction, because in many countries, the right to marry has been found by courts. So these two questions on judicial activism and on the litigation strategy of the petitioners.
Yeah, I mean, I guess obviously if a matter goes to the High Court and is decided there one way or the other, you have another round, you have another forum in appeal, right? So obviously that is there. If petitions are heard directly by the Supreme Court, then you have just one shot. And of course, curative review, all those options are there, and I'm not commenting on those. So yes, going to the High Court gives you another another option to go to the Supreme Court. That's what's happened in the marital rape case. The marital rape challenges went to the High Court. There was a split verdict. Now it's gone to the Supreme Court, and we have to see how the Supreme Court decides. So yes, these options are there, but what has happened has happened. I think now we can't undo what has happened. So, so we are where we are. And the other question, sorry, what was your other question?
The other question was on judicial activism, because in many countries it's been addressed by the courts.
Yes, I mean, see, on judicial activism and whether this could be addressed by the court, I mean, I think I have a little more nuanced response to that. Yes, our courts have also been extremely proactive in many instances of protection of fundamental rights. But I think on the issue of marriage, yes, we did rely on many other judgments, but I think every legislation and every context is different. We got early signs, even during the arguments, that many of the complications in the Special Marriage Act, I mean, there are complications in the Special Marriage Act. It's not a straightforward legislation. I do agree with the issues that the court has raised, that just a mere kind of replacing of man and woman, or bride and bridegroom, with person or spouse, it's not that simple, because there are many sections in the Special Marriage Act that require more work. Could the court have done it? Yes, we argued that the court could have done it. The court decided that it could not. But there are many provisions that require far more work. There are provisions that address, rights specifically for women. And the question then raised was, how does that affect a situation where both parties to the marriage are of the same sex, whether both women or both men, or queer persons, or gender or trans persons? So, those questions were there. There are issues of, certain sections relating to, inheritance. So I don't think we can look at the act being direct. The judgment cannot directly accept what another jurisdiction may have addressed, because our marriage law is quite different from other marriage laws. Yes, the principles of expanding the right to marry to persons irrespective of gender identity and sexual orientation is what we argued. Many other courts have done that. Our court gave reasoning why it couldn't. Though as petitioners, we did give several options how the court could have addressed it. Could the court have left out some of the aspects on personal laws, on inheritance? The court decided that it could not. So, we have these, now we have this judgment. And so, yeah, I think now the buck really falls back to petitioners, to the movement, to the civil rights activists, to see how do we want to now take this forward? What is our strategy? How do we work towards recognition of these rights? And how do we work towards it in a constructive manner? And I think we need to really deliberate on that.
So, ma'am, to that point about the buck now being passed to the petitioners and civil society, essentially, there is a question that someone has asked about: if somebody wants to now get their marriage solemnized and they go to a lower court, would this judgment stop their marriage from being solemnized? In addition to that question, I also want to ask a point, just highlight a point that senior advocate Mukul Rohatgi had made regarding the age of the petitioners. And he had said that, time is passing by, the same-sex couples are growing older. And while they've spent so much of time being in a relationship, while we wait for this discussion to have, their lives are passing by. So we need the court to address this issue now. And I also feel that to some extent, this issue of time and timeliness was not really addressed by any of the justices, because, while they have compared the right to ask for the legal recognition of marriage similar to that of a poet seeking a stage to speak, I view it through the lens of, it being an issue that is very timely, and it being an issue that affects people who've been in relationships for so long. So what is your response, or to this point about time, and especially to people who feel that they may not live long enough to see their marriages being legalized by the courts, and also young couples who now recognize their rights, who now recognize that, yes, I am queer, there's nothing wrong with me. But when they go to a lower court, the lower court will potentially say, sorry, Suprio is a precedent and we can't recognize your rights. So what are your thoughts on this?
With this judgment, to go to a lower court and, seek something of a recognition to registration, I don't think obviously that will work, because you have a 5-judge constitution bench staring at you, right? So I don't think that is going to work. We have to look at different strategies. I would say better strategies would be perhaps, see, everything cannot come through court. Court, I think it's a mistake as lawyers. Yes, we believe in the courts, we hope in the courts, and courts litigation and using the law is our work, but not everything can come through courts. And even when things come through court, it cannot come only from the court. What work we do in the court has to be supported by activism on the ground, by work on the ground. It can't just, it's not, I mean, if that was the case, then everyone would rush to court and we would get whatever we want, right? That's not so easy. It's never been that easy. And so therefore I feel that we are all guilty of that. We've all been going to court. And yes, we've been getting quite a few wins, but I think this judgment is a reminder to say that we have to look at other strategies as well. And how do we do that? Maybe take up smaller issues that perhaps could be low-hanging fruit, and which would still not be perhaps affected by this judgment. Can we do that? Secondly, I don't think we can use the argument that time is rushing by. Yes, time is rushing by. There's no denial of that. But, time is rushing by for everyone. I mean, women facing domestic violence didn't have a law, and they were dying. I mean, forget about age of marriage. They were being killed and they were dying. So can you tell the court, oh, time is rushing by, enact a law? So I don't think that is an argument, but I think we have to look at newer, creative ways. I think we have to look also at traditional ways of campaigning for legal rights that historically movements have done. Movements have always worked on the ground and used the law to support their on-the-ground work. And so I think it's time that we go back to that traditional form of really seeking law reform, which is hand in hand with seeking of rights on the ground. And so we just have to do that, and do it in a way that hopefully will not take too long.
Ma'am, that point that you made about grassroots movements and about women's movements, you mentioned this in your Deccan Herald article as well, which I think is very pertinent, that women had been fighting for the recognition of domestic violence, not just within the marital home, but beyond the marital home. It took a long time, and finally the DV Act was passed, and now we are seeing, we're going to see what happens with marital rape. So these things take time, and so let's see what the future holds for the queer community. On that note, just a few pointers. So it's almost 7, so we'll take one last question. But the NLS, Kautilya Society and Queer Alliance are going to compile the questions that are unanswered, and they will send it to the panelists post the event, so that those that are unanswered will have a chance to be answered because of paucity of time. So one last question, I'll maybe maybe Rohin and Muskan, if you could just quickly answer this question, both of your thoughts on this one question, and then I'll pass it on to Nidhi to close it. So this is a question about whether about impact litigation. So the anonymous attendee is asking that not all queer persons would have advocated for this strategy, which is take 10 to 12 petitions, go to the Supreme Court. Now, at the time when this case was being heard, a lot of people were waiting with anticipation, and they also felt to some extent, including myself, that the judgment would be positive, because we've seen Justice Chandrachud, we've seen some of the other Justice Call also. We have an understanding about their position on queer rights. So we went with optimism. And at the end of it, what did we get? We found out that marriage is not a constitutional right. Now that's part of the law. So this very good question by anonymous attendee, which is that Should there have been widespread consultation prior to filing these petitions? Because now the impact is being felt by people who may not have endorsed this strategy in the first place. So Rohin and then Muskan.
I think that is the nature of the game these days. I think, one petition is filed and 20 more are filed in every matter of public importance these days, be it, Article 370, be it, say, for example, challenges to CA, 6A, right? Even in marital rape, there are 4 petitions that are pending before the court. So the nature of the game is such that everybody wants in, so to speak, right? And especially when you are on a winning wicket, everybody wants in. I think a lot of us went in with the optimism that this was the best shot we'd had in decades on queer rights. Because judges had been so forthcoming, not shying about speaking about their positions. So that is the first part. But I agree with the question that, look, there's a need to have broader consultations. Let's talk, for example, this new petition that has just been filed around seeking reservations for trans people in the Supreme Court, Subi KV versus Union of India. Now, a lot of us found out that this petition was filed only when, when Bar and Bench and Live Law reported on it. And a lot of us who were kind of engaging with the horizontal reservation movement were caught unawares, right? So people are rushing to court, and there's not to say that people shouldn't rush to court, right? If your right is violated, you have the full freedom to rush to court. But especially when you are doing so in cases of PILs where a broader community is affected by the outcome, I think there is a conversation to be had around whether consultative processes should be in place or not. Again, yeah, that's about it.
Over to you, Muskan.
I think it's a no-brainer. Consultations are absolutely required. This is something that the queer movement went through with NAS Foundation, where the biggest critique was the NAS Foundation didn't do when the judgment happened. It wasn't after a consultative process. And since then, I think the ethos of consultation has been something that is very much embedded in parts of the queer movement. But there is absolutely no question that any sort of impact litigation has to happen with consultations with not just, say, the queer movement, but also intersecting movements who will be impacted by these things. Because a court judgment, like we see with this, impact litigation is amazing, and it's something that we all want to do because of its emancipatory potential with the law, right? Like, the court declaring a right can have large scale impact, but that could also be a double-edged sword if it's not done properly. So in recognition of that, it is our imperative to do impact litigation of this scale, with consultations, with ground level movements, with thinking of going to high courts first, because these things have to be built. That's the only time that at least history has shown that they have been successful. And because after that, it then falls to the people on the ground, right? Now it's the crisis intervention NGOs on the ground who have to deal with police people saying, but you don't have a right to marriage, like, why should we let you stay together? So I think as lawyers who approach the court, it is definitely our imperative to ensure that we do this with consultations.
So it seems to me that there is a unanimous consensus in the panel that we need to consult the community at large, and that this has to be a grassroots movement, the way the women's movement has been for so many years. And there is a lot that we can learn from the women's movement. Pride, this is Pride season in Delhi. We're going to have a Pride parade very soon. And I believe some other cities are also going to have their Pride parades. So I think this is an important moment for queer organizers to think about what they want their parcha to have. So in Delhi, we have a Pride Parcha, which is a list of demands by the queer community. It would be good to revisit last year's parcha and see what has been achieved, what hasn't, what do we want to achieve going forward, and who do we hold accountable for this, because the ball is really in our courts. involve more women and get more involved with what and understand their strategy. I think that's also important. And overall, I think while this is a very, very concerning verdict for many queer people, it is also it's also important for us to reflect on what the next steps are and what we can glean from it, and take it to the people and see how it goes from there. We really don't know what more we can do now except wait and watch and hope that things work out well for everybody. So on that note, I'm trying to end on an optimistic note, although very hard to find optimism in these dire times. I'll pass it on to Sarthak to close this discussion. It's 7 o'clock, so I'm glad that we were able to stick to the time limit. So over to you, Sarthak.
Yeah, thanks, Kanav. Thanks a lot. I'll just take a minute and just thank everyone for coming. We had good participation for this, and it was a very informative session. So thanks, Rohin, Muskan, and Jayna ma'am for coming. Also, thanks to Nidhi, Prajwal, and Dhawal who couldn't be here for helping organize everything. And thank you, Kanav, for those questions. We'll see what we can do about the pending questions, and we'll send them over to the panelists soon. But yeah, we'll end the session now, and we'll post it on our social soon, and we'll let you guys know when that happens. Thanks a lot for coming.
Thank
Thank
you.
you.
Bye.
Bye.
Thank you. Bye.
Bye.